And guest this evening on Oral Gibbes Live is none other than Deputy Governor and Attorney at Law, Mr. Reynold Groeneveldt. How are you doing, sir?
Good evening, Mr. Gibbes. Good evening, televiewers. I'm doing okay, and I'm very happy to be here again after a long time.
Well, it's good to have you in the program, and I'm sure you've been observing all the different things that's been happening on St. Martin political-wise.
Yes, quite a lot has been happening, but before we go into that, I would like to, say a word of thanksgiving to our Lord for sparing us during this year as we are approaching the end of the year, and we are fortunate that we did not have any hurricanes, any storms, any earthquakes, and all of that. So we have to give God thanks for that. We have been having some issues on the island, and crime is one of them. Worldwide, that is such a big problem worldwide, and also here on the island. Even up to yesterday, a gentleman that I knew very well working at the gas station was just gone down, and that is so sad. And we have to pray about that and hope that people's minds would change. If you're going to rob some money, rob, but don't kill, for instance. But we have to remain optimistic and do what we have to do for our island.
Well, it's so strange because it seems like in the past, when there was a murder, everyone will be upset about it. Now it's like people don't care anymore.
It's happening too often.
Yeah.
It's becoming something normal, whereas it should be considered as something unusual and abnormal.
So now when you look at, we now have a new government, and a lot of things, there was a lot of problems, but I would like to say here and let people know that you're one of the persons who worked along before St. Martin obtained its special status as a country within the Kingdom of the Netherlands, along with some others. So you're privy to a lot of information that we didn't know at the time, right?
I believe so. Yes, I'm one. Maybe much people don't know this, but before we approach the date of 10-10-10, there was already a draft constitution prepared. And Mr. Gaston Bell, who's also an attorney, and at the time, Monique Murray, she worked as an attorney for the government around the year 2000, 2001. And myself, three of us, we made an initial draft of the Constitution. And that we did that just after the referendum. And I believe the referendum was in 2000. And then when we get closer to 10-10-10, the government and the advisory body said, we need a constitution. So we said, we have a draft already, here is it. And then they worked on it and improved on it, add the Bill of Rights, expanded those. So I can say that I have been involved with the Constitution from the beginning, yes.
So let me ask you, in that draft, did you all have Article 33 and Article 59 in the draft?
Oh, yes.
Yeah.
Yes. Those are two fundamental articles of our parliamentary system. So they were there in the original draft, yes.
But there are articles that create problems now, according to some politicians.
According to some, unfortunately, I think we have to learn and read up on the history of those two articles, see how they have been applied, understand how they're supposed to be applied, and not just apply them at any time we feel like. That is not the intention of those articles. Those articles are also in the constitutions of Aruba, in the constitution of Curacao, in the constitution of Holland. But also I've been doing some research and look at some constitution of other countries here in the Caribbean. And St. Kitts constitution has similar articles. Barbados constitution, St. Lucia, Grenada, all those independent countries have those, have similar articles in their constitution. And those are two articles that are derived from the Westminster system of parliamentary democracy, which is meant that Parliament has to control government, but government also has that tool, that instrument that it can exercise checks and balances on Parliament. But when government make use of that Article 59, in the Constitution, it's mandated that the issue is referred back to the people. And there's where the early elections come in. Because then it's the issue supposed to go back to the people, and then the people have a vote, and based on how they would vote, they would indicate whether they agreed with Parliament sending home government, or whether they agreed with government dissolving the Parliament.
So when you look at it, because some legal minds are saying, look, this Article 59 gives the Council of Ministers, which is the government, a legal tool and power to deal with a parliament who says, well, we don't have any confidence in you, so we send you home. And Article 59 is invoked by the government to say, okay, now we got you, go back to election. Let's see if the people agree with you.
Yeah, and that's democracy. Some people say, I hear some people say, Parliament is the boss. They appoint the ministers. That is not really accurate. Yes, Parliament has more authority than government because the parliamentarians are directly elected by the people, so they have a direct mandate from the people. The Council of Ministers not, but they derive their authority and their competency from the Constitution. And they're supposed to keep each other in balance, in a check and balance. And if they do not use those articles, or those articles supposed to be used in very, very extraordinary circumstances. And if they don't use those articles for every little argument that they get into, then there would be no problem of instability. I've looked in St. Kitts Constitution, and there it stated that the Prime Minister, if a motion is passed against the government, then the Prime Minister has 3 days that he can either accept the motion of no confidence, resign, and go home, or he can instruct the Governor General to dissolve the Parliament. In Barbados Constitution, it stated that the Governor General, acting in accordance with the advice of the Prime Minister, may dissolve Parliament at any time. But it does not happen. The Prime Minister would not do that, just go and dissolve Parliament at any time for no particular reason. But those articles are there, but it does not mean that we have to be making excessive use of them. And that is unfortunately what's been happening here in St. Martin.
So now in our makeup here now, where does the governor fit in all of this? Because we heard, that the governor had to sign the decrees, or if he didn't agree, he had to send it to the Hague. What's going on here? Can you explain those?
Yes. In our makeup, the governor has a ceremonial role. The governor represents the king, and the king remains above politics. And the governor is also head of the local government. So in that sense, he has to sign the decrees, and there are guidelines and rules, when the governor should not sign a decree.
So he must sign a decree?
Basically, yes, unless it is in conflict with the law. with the interests of the country, with the interests of the kingdom, or with an international treaty, then the governor may not sign if that is the case.
And then what happens then?
If the governor does not sign, then the decree is sent to The Hague,
Okay.
and then the Council of Ministers will enlist the advice of the Council of State, and they would advise the Council of Ministers, and then the Council of Ministers will determine whether the governor should sign the decree or not. That is how the system is set up.
And that didn't happen in our last political crisis that we had.
That did not happen, no, no.
So because we heard so many people saying, yeah, but it should be sent to the Hague for review, etc. When you look at the situation that we experienced here, you had one group of people who felt that it was okay for the Prime Minister to dissolve the government, while a lot of other group of people said, well, you know, the government was sent home by Parliament, and that includes the Prime Minister and his cabinet, and they had no real legitimate power to dissolve Parliament because they had already been sent home by a vote of no confidence.
Yeah, but that's not correct. That's not accurate. And the advices of the constitutional experts and also the advice of the 3 judges indicate clearly that even if the government have been sent home or a motion of no confidence was passed, even if they had submitted their resignation letters to the governor, they become demissionary, but they can still make use of that Article 59, because that Article 59 is a right, is a competence, is an authority that was given to the Council of Ministers. And the article says they can use it. So they don't have to. They can refrain from using it, but if they think under these circumstances we going to make use of this article, then they are in their legal rights constitutionally to do so.
Do you believe that these articles are open for abuse?
Well, the articles, as I said, are meant not to be used too often, because if you use them all the time and you use them for matters that could be resolved by negotiation, for instance, then the articles would not have their full effect anymore, and it's going to create, as we are experiencing now, too much instability in government, and that is not good for the country.
So when it comes to Article 33, where the Parliament have the power to dissolve, to vote of no confidence, vote of no confidence against the government, that, in a way, this government, the previous government, claimed was not done the proper way because the Prime Minister was out of the country. There were no real reasons given why the government was, why there was a vote of no confidence against the government. Now, according to the Constitution, and I'm asking you as an expert because I don't know, is it important that if Parliament is going to have a vote against a government, that the Parliament must motivate that vote of no confidence with a real reason why they are dissolving, why they have this vote against government?
No way in the Constitution is that stated, And you see, constitutional law consists of written rules and unwritten rules and unwritten norms. So the group of people that would say, yes, the ministers should have been invited, there should have been a debate, those sentiments, those feelings are not based on what is written in the Constitution, but what you might want to say is an unwritten rule, or what would be maybe in some places customary, or what would be advisable. For instance, when the government is going to make use of Article 59, some scholars say, and again, it's an unwritten rule, that the government should consult first with Parliament before they make the decision, and only if Parliament agrees to it, then the decision should be made. Another group of scholars are saying, no, if you do that, then that would mean that the article or the competence is not a competence, a sole competence of the government, because then they can only use it if Parliament agrees to it. You see, so you always have two schools that one school will look at it this way, the other school will look at it a little differently.
But didn't the Dutch government review Sint-Maarten Constitution before it was approved?
Yes, they did. Yes, they did, and thoroughly. Interesting, the Article 59 in the Dutch Constitution their article is 64. Our Article 33 does not appear in the Dutch Constitution. In the Dutch Constitution, that rule that a minister or council of ministers can only govern if they have the confidence of the majority in Parliament, that in Holland, that's an unwritten article of law. It's not in the Constitution.
So if Parliament vote against you, just go home.
Yes, they don't even have to put it in the Constitution. Okay. If the Parliament, the majority in Parliament bring a motion, that's it. It has the same effect as if it was written in the Constitution. And
because we are different here.
We are very different here.
We want to see everything in black and white.
Yeah, and that's one of the reasons that we put it in our Constitution. I think that happened back in 1938 or 1940, sometime around there. But Article 64 in Holland and our 59 was in the Constitution in Holland from 1848. And in our first Constitution, we got around, I think, 1934, 36. Then that came over in our Constitution. So the article giving the government the authority to dissolve Parliament was in the Constitution before the Article 33, which states that Parliament can move a motion of no confidence, and then the minister or the ministers have to make their position available.
In the former Netherlands, didn't the governor have more powers in the Constitution?
Yes, in the former Netherlands Antilles, the article in the Constitution read that the governor would dissolve Parliament. But as we develop and we move along, and you've seen in Holland also that recently some decisions were made that would limit the involvement of the king. For instance, with the formation of a new government. Here, the governor still does that. So in preparing the Constitution for 10-10-10, that was changed, and the authority was given solely to the Council of Ministers. The article says that Parliament can be dissolved by a national decree. And a national decree is a decision made by the Council of Ministers.
And signed by the governor.
And signed by the governor and co-signed by the Prime Minister and one or more ministers.
So when you look at Sint-Maarten now, and we've had 5 years of what they call ship jumping, I call party jumping, and a lot of people are angry about it. But if you look back at it, and in the last few months, I've changed my view about it. In fact, I like the idea that it's possible to jump ship.
Yes, that's one of the fundamental freedoms of that parliamentarians have in our system. I too think I love our constitution. I hear people say it's flawed and they want to change it, and I think Dr. Romney is now busy with a law to stop ship jumping, and I don't think we should do that. I don't think it's possible. That would be a huge undertaking to change that, because basically you're going to change your whole system. And the idea, the Constitution does not say parliamentarians are allowed to ship jump or to leave their party and form new alliances and so. No, it does not say that, but it's a result from the system. And Article 61, I think subsection 2, says that a parliamentarian votes in parliament without, in Dutch they use the word last, without instruction. So they have a free mandate. Once you are elected, you are sworn into parliament, you have a free mandate that your political party or the people that voted for you or the people that did not vote for you, that they cannot tell you how to vote. They cannot bind you to vote in a certain fashion. You are free to vote how you think or what you think is best for the country. In Aruba, for instance, I think they had the problem with ship jumping. They got their status apart in 1986. And I am reading a decision from the Supreme Court in Holland from 1988. And apparently, the Democratic Party in Aruba made their candidates sign an agreement that once they are elected, if they leave the party, they have to give up their seat.
Is that legally binding?
It's not legally binding. It went all the way to the Supreme Court, and the Supreme Court said that agreement is null and void. It's not legally binding. It's in conflict with the free mandate that a politician, a parliamentarian has.
So then how are we going to make amendments to this constitution that is flawed?
Well, to amend it to say that you cannot ship jump, or if you leave, you have to give up your seat, that is going to be termed in conflict with the jurisprudence of the Supreme Court. If you change the electoral ordinance and put that in that is also going to be challenged. That is going to be void, because then the electoral ordinance will be in conflict with the Constitution. And the ombudsman can challenge that. But also in our Constitution, there's an article, judicial review, that if an ordinance is in conflict with the Constitution, that a normal citizen can go to the Court of Justice and challenge it, and the judges will look at it and most probably rule it unconstitutional.
So right now we have members of parliament that are saying this constitution for Cimarron is flawed. People are not happy. These are people that were elected by the people of Cimarron. They're the highest elected body. The members of parliament, they're the ones, some are saying it's flawed. And they're now looking for a change.
Yeah.
So
I totally disagree with that type of thinking. I think we have a good constitution. Of course, there are always rooms for improvement, but to say it's flawed, it's not accurate, and it's not fair. Within the kingdom, our constitution is the most progressive, the most modern, the most progressive, compared with the other constitution of the other countries within the kingdom. What we have to do is understand how the constitution is put together, how it is structured, what are the competencies of the government, what are those of parliament, and how they should be applied. But to just say that it's no good, it's flawed, and we need to change it, that is not, according to me, not accurate.
How many constitutions are there in the Kingdom of the Netherlands?
The Netherlands has their own constitution. Aruba has their own constitution. Curacao has their constitution, and St. Martin. So 4. Each of the countries have their own constitution.
And but of the 4 countries, who maintains the supervision of changes?
Well, certain changes that any of the countries are going to make have to be approved by the Council of Ministers in The Hague.
Okay.
Yeah, so you just cannot change all the articles. And when it comes to fundamental changes, the Council of Ministers in The Hague have to approve it. And customary is that those proposed changes are also sent to the countries, to the other countries, so that they can look at it and comment on it and give their feedback.
Right now, there's quite some similarities among all of them, right?
Yeah.
If this proposed change to correct the flawed constitution, as some of our members of parliament are stating, to impede members of parliament from jumping from one party to the next, wouldn't that be in conflict in
yes,
the whole
and I
system?
don't see it meeting the approval of the Kingdom of Ministers, and I can see negative reactions coming from the other countries as well. So that's one of the reasons that I said to it's a huge undertaking and virtually impossible to change that, because then you'll have to change your whole system, and then being a country within the kingdom, the other partners are not going to agree for you to have a totally different system than they have within the kingdom, because then that similarity, that uniformity will be gone. We had a lot of problems to get them to approve that we would have a constitutional court, for instance, because they don't have it. Although it's something very, very good, I think in the end, that's why they agreed, well, okay, you all can go ahead. But we had to do a lot of talking and negotiating to get that approved.
And in the last crisis we had, with since we have this constitutional court, it didn't play a role there.
No, because the jurisdiction is too limited.
Okay.
And right now, only the ombudsman can initiate a case at the constitutional courts, and then it has to be a law that has been passed by Parliament, but not yet promulgated, meaning that it's not published and gone into effect. And if the ombudsman observes that certain things are wrong in the law, then it can be challenged before the Constitutional Court. But I think the jurisdiction of the Constitutional Court should be expanded to include conflicts, for instance, between government and parliament, that you get a ruling, and also conflicts between the countries within the kingdom, because right now the Council of Ministers deal with those issues, and I would prefer to see that being dealt with in an independent constitutional court, and even one that is set up as a court for the entire kingdom. So every country can have their own local constitutional court, and then from there you make one supranational constitutional court that will deal with conflicts that Aruba might have, with the Kingdom Council of Ministers, or the other way around.
During the last crisis we had here, I noticed that a lot of old people were very confused, didn't know what was going on. What do you think about that?
The debate that we've been having, I think, is healthy, is good, But unfortunately, there are some people that overnight claim to be constitutional experts and do not read sufficiently or do not understand or know the background of certain articles in the Constitution or certain interpretations. And by them coming forward with particular views, that has been somewhat confusing to people. And that is why I'm happy. I waited because in my position as deputy governor, I have to be careful, when I give an explanation or I say something that people don't look at it politically, because as deputy governor, the governor himself, we try to keep away from politics and be neutral so that we can deal with all parties, all individuals. But I'm happy for this opportunity to be able to come on your program now that the storms have died down a bit and give an objective and an academic explanation as to why those articles are in the Constitution and how they should be applied and how they should be interpreted.
And the Constitution is also in English, so anyone can go and read it.
Yes, it's in English, it's online, so people should read it. But what you should also do is there are books at the library, for instance, but also online. You can find a lot of information online about these type of issues that you can read and get that background information, and then you would understand much better, what the article means and how you should interpret it and understand it.
This gentleman is one of the few, it was, how many of you, 4 or 5 of you in the beginning just did most of the preparatory work?
The draft, yeah, 3 of us.
But besides that, you was also involved along
Yes.
with others in the
judicial committee
Right.
that vetted the Constitution and the consensus kingdom laws.
Oh, okay. All right, let me take some calls because of people calling. Oral Gibbes Live, you're on caller. Hello. You're on live caller. Hello.
Yes. Honorable.
Oral Gibbes Live, you're on caller. Hello.
Hello.
Yes, go ahead. You're on live caller.
Hello.
You're on the air live.
Honorable.
Good evening.
Deputy Governor Groeneveldt.
Good evening, sir.
Good evening to you and your host, Oral Gibbes.
Good evening to you, Doc.
I think what should be done in question to the Constitution, I don't know if it has changed, but when it was issued, they were done like a sort of a pamphlet, a thick pamphlet. I think that should be something scrapped. Handsome looking books should be nicely made, whereby people can purchase those books and have, instead of this, the several papers clipped down and all this kind of a thing. Don't you think that should be done?
I agree with you, Mr. Lake, 100%. As a matter of fact, as you may know, I'm also becoming a senior citizen. I'm over 60, so I have changed my focus in life, and I'm going to court less. I'm doing less litigation, and I'm busy, as a matter of fact, with 2 books. One book is going to deal with exactly what you just suggested, that thorough explanation is given of our constitutional system, the Constitution, Parliament, and government. And the other book that I'm busy with, I'm still in the phase of doing a lot of reading and research, but the other book is I'm going to propose a model of, for independence for the future, how St. Martin can become an independent state in the future. There's a lot of talk now if we are a country or not. I am of the opinion that we are a country. We can qualify to be called a country. And I'm going to deal with that in my book that I'm also preparing. And hopefully I can, get to sit down every day and try to write a chapter so that I can have them ready sooner than later. But I agree with 100% with your suggestion.
Thank you very much.
All right.
You're welcome.
Thank you, Mr. Lake.
And don't
Oh, sorry. Oh, sorry, Mr. Lake. I never thought he wasn't there. But when you mentioned about country, most people, when we hear country, it's a sovereign state.
Yeah.
And the sovereign state in St. Martin is not there because the sovereign state is the Netherlands.
Yeah. That's correct. And we have never said we don't profess to be a sovereign country, because we are not. The kingdom is the sovereign entity. But based on, for instance, if you look at the United States Resolution 1541, after 1960 in the decolonization period, it states that you, as an emerging country, you can choose whatever form of association you want once you obtain a level of self-government. Then you're no longer a colony. So in our case, we have chosen to become a country within the Kingdom of the Netherlands. And the word country, state, and nation, those words are used sometimes meaning a sovereign entity, but sometimes meaning a non-sovereign entity. Take, for instance, New York. And last Friday, I believe it was, or the week before, there was a symposium organized by the Surinamese community. They were celebrating 40 years of independence of Suriname, and I was fortunate to be able to give a presentation there. And I explained, when you say the state of New York, the state means a country, but New York is not a country. It's a, and what Dr. Romney liked to use the word constituent state. And yes, it is a constituent state. We are also a constituent state, but also a country, because when you look at the Montevideo Treaty, that gives the criteria, the requirements that you can become a state. And one is you have to have a territory, you have to have a government, you have to have people, and you have to have the capacity to enter into international treaties. Now, he is saying, and I heard him on several programs saying, we don't have that capacity to enter into international treaties, but he's wrong, because if you read Article 26, Article 3 in the Kingdom Charter says, yes, foreign affairs is a competency of the kingdom, but Article 26 gives each country within the kingdom the capacity to enter into a treaty by itself. So if St. Martin wants to enter into a treaty with the United States or with Canada, we can do that. And that authority is given to us in Article 26 of the statute, the Kingdom Charter. So we do have the capacity to enter into, but we have not declared ourselves to be a subject of international law. We have not applied for membership with the United Nations. So we are not sovereign because we have not done that. But we meet the requirements that we can do that. All we would have to do is make certain arrangement for those competencies that are dealt with now by the kingdom government, for instance, defense, foreign affairs, our nationality, expulsion. Expulsion, I think we can deal with that easily. Defense, I mentioned during the symposium that, for instance, Monaco is a small sovereign country. They have a treaty with France for their defense. In the South Pacific, there are a lot of small countries like Nauru. There's a Palau that has an association with the United States. And that little country with about 15,000 inhabitants, they are a member of the United Nations. With voting power, you have Cook's Island that is close to New Zealand. So there are possibilities where small microstates can become independent, with the assistance of a bigger country for their foreign affairs, to help them with foreign affairs, their protection and so, but it is possible. And that's the subject of my second book that I'm busy with.
In a way, that's what we are, almost.
Almost.
When it comes to the kingdom.
At the symposium, I said we are almost independent. We are more independent than we think. We have to start thinking that way and acting that way. And then in due time, it's just a matter of sitting down around the table and making different arrangements for those areas that are not our competency now. And I don't see us ever being able to set up a defense, a force with ships and an army and those. So we have to depend on a bigger country, a bigger nation for that, even after we become independent. So the word independent is very, very, very relevant, and the concept, and I'm dealing with that also in my research, the concept of independent has changed over the years. It's a different concept right now.
But I want to go back to treaties. When there's a treaty signed by the Dutch government, the kingdom government, we in St. Martin must also sign that treaty, right?
No. We decide if we want to be bound by the treaty, yes or no.
So then why is it that the treaty, the friendship treaty, is a problem right now, whereby this is a treaty between the United States and Holland, and they're saying, well, St. Martin, you're bound by that?
Yes, that treaty, that was entered into, I think in 1936, years ago. And indeed, in that treaty, it is stated that it's also applicable to the countries overseas. But any treaty that is being worked on in The Hague, in the draft form, it is sent to us in St. Martin, to Aruba, to Curacao.
Oh, okay.
It goes to the parliament, it goes to the government, and those things, they come via the governor's cabinet now, and then they are disseminated. And the government, together with parliament, decides if they want to be bound by the treaty, yes or no.
Oh, okay.
If they want a reservation, that they say, no, we don't want this treaty to be applicable for us now, or we don't want this article or that article to bind us, the rest of the treaty is okay. Or they reserve that the treaty will come into effect for us 5 years from now or a year from now. So we have that autonomous freedom that we can say no. If we said we want to be, then it would be signed for all of us. If we say no, then it would only be for the Dutch part of the kingdom.
So that came in after 10-10-10?
No, before. So I guess the friendship treaty, I guess back then that time we didn't have the Netherlands Antilles. Netherlands Antilles came into being around 1950.
That was before we had West.
Yeah, so that was before. So then probably they took the decision that it would be applicable for all the territories.
Okay. I mean, personally, I don't have a problem with it. I think it's good to have a treaty like that with the United States. However, I would like to see reciprocity.
Yeah, and I
I think
don't
that
believe that's there in the treaty. That's
Yeah.
not there in the
Yeah.
treaty, yeah.
All right. You know, when you look at the island, and we have now 5 years since 10, and this whole system of government is new to us. We make mistakes. We still don't understand Parliament and Council of Ministers. We use it interchangeably and everything else.
Yeah.
It seems it's taken us a long time to really catch on to the whole thing.
That's true. For some people, the system is still confusing to them. It's taken a little too long, but I think programs like this will help people along if people start reading a little more, going to the library, going online. And with Google, it's so easy to find information. You just type in the topic that you want to read about, and you get a whole list of articles and references. But education is the key. I think we all need to educate ourselves. We need to continue to read and do research, listen to people who know, and try to learn and understand. And I think once we do that, in the United States, people know their basic laws. They know their human rights. So we have to try and get to that level.
Okay, take some calls. Oral Gibbes live in caller. Hello.
Good evening.
Good evening.
Thanks to the Deputy Governor. Good evening to you, Mr. Gibbes.
Good
Good
evening.
I
evening.
would like to ask the Deputy Governor if it is right what the Prime Minister did by saying he will not resign until he signs the document to dissolve Parliament. I would like to know if that was right what the Prime Minister did. Good night.
Yeah, I'm not going to get into who was right and who was wrong, if the Prime Minister did the right thing or he did the wrong thing. I think he explained what he did.
Yeah.
So I'm not going to say whether he was right, whether I think he was right or he was wrong. It's not really relevant. But I think if you follow my suggestions and read up on the matter, then you can determine for yourself whether you think he was right or whether you think he was wrong.
Yeah, and he was here in this program, and he explained
He
why he
explained
did
it,
that.
yeah.
Oral Gibbes live in caller. Hello. You're on live caller. Hello.
Yes.
Yes.
What I'm saying is we are autonomously independent. You kicked me off.
No. You're right there. You're on the air live. Go ahead. Go ahead.
Sorry, excuse me.
Go ahead.
We also have an opportunity if we choose to want.
Go ahead, speak it.
If we choose to want to be, how you call it again? There's a word for it. But anyhow, it's being in association with Holland, yet independent, but there's a word. It's to the tip of my head, like some people have said.
Uh-huh. Yeah, we have an autonomous status, and we are self-governing in
Yes.
all governmental competencies, with the exception of those 4 or 5 that I mentioned just now, like foreign affairs.
But what I'm saying is, it's what some of the independent countries have. That although the king would be recognized,
Well, we're out of time. I'm sorry, Doc. I
much like a crown.
only got a minute left. I want to give
It
Governor.
has to come to me, but
Okay. But thanks a lot for calling. Really appreciate it. Okay.
Thank you very much.
Thank you. We only have a minute.
A minute?
Yeah.
Okay, yeah. First of all, I would like to thank you for having me here on the program. And I cannot stress, every time I come here, I stress the importance of education. And one of the areas that we are looking at right now, a group of lawyers and friends of mine, we have approached the University of St. Martin to establish the law faculty.
Oh, okay.
So we are going to be making that public. I just did it now, and we are going to be conducting a survey soon to determine the interest, to see how many potential candidates. Because I think one of the pillars of any country is your legal minds. The laws are very important, and at the university we need to establish such a faculty, train our local persons to be lawyers so that they can support parliament, they can support government, they can support business, and that in that way we can make our contribution to help develop and strengthen our country.
All right. So I sure we by 2016 we
Hopefully we can start it in September 2016. We hope to be able to start.
Well, Governor, I want to thank you for coming and being my guest. I want to wish you and your family all the best for the holidays.
Thank you. Thank you for having me, and also all the best to you and your viewers and the population for the Christmas holidays coming up. Thank you.
Thank you. And that's it for now. See you next time. Until then, good night. Take care. Bye.